Hello, everyone. Good evening. Welcome to our panel on the shutdown of legal routes for refugees and the 2016 March of Hope. My name is Alexandra Bogos, and I am with the Border Violence Monitoring Network, and today I will be the moderator of the panel discussion. Can everyone hear me and see me okay? Yes? Okay, great. Lovely seeing you all here. I'd like to welcome you and welcome the participants here today, Hanna Hakiki, Marta Gorkinska, and Zoran Drangovski. They will be taking turns in speaking, but first and foremost, the reason why we are here today is to introduce the judgment communicated this morning by the European Court of Human Rights, AA and others versus North Macedonia, a case that was supported by the European European Center for Constitutional and Human Rights, and who have been today communicated the verdict and will be introducing the case and will be discussing this case today in this panel. If I understood correctly, there is a video that explains the case that our support will play after me speaking. So the time has come then now to play the video that would introduce the case to the audience. Thank you.
Hi, I'm Diana from Aleppo, Syria. We are not criminal. We just want peace for our children and a future for them because we don't have it in our country. The condition in the camp of Idomeni, it was very bad. We live in field of mud. We went with my family and 2 young children to March of Hope at 2016 because the ASYL border was closed and we have no other way. They made us sleep under the rain during the night, and in the morning with their dogs and weapons they told us to go back to Idomeni. I'm waiting for justice for us because we are not criminal. Thank you.
Thank you very much. I hope the video was informative enough for everyone to have an insight, for those who don't already know, into the case at hand, but also into EU migration policy and how borders have changed and legal routes have changed since 2016 with the closure of the so-called Balkan migration route. Our first speaker here today is also the representative of the case, Miss Hanna Hakiki, who is a lawyer and a senior legal advisor at the European Center for Constitutional and Human Rights. She works in the migration team, which supports migrants and refugees challenging pushbacks and claiming their rights at the EU borders. Hanna, would you kindly tell us how you and your team have received the judgment? What is the judgment about? And how the applicants themselves have reacted to the judgment communicated by the court today.
Thank you, Alex. Here the European Center for Constitutional and Human Rights supported the litigation of the case. The representative of the applicants is our cooperation attorney, Carsten Gericke, so not me. The case has 8 applicants. It was filed in 2016. It focused on the prohibition of collective expulsions under Article 4, Protocol 4 of the Convention. And I have to say, to replace this is before we get the Grand Chamber decisions in Khleifia versus Italy. It's before we get the Grand Chamber decision in NDNT versus Spain. And what the case is about, I think, is the closure of borders that happened in Europe after a common decision of a number of governments, and that was applied at the same time in a number of borders at the 8th of March 2016. And this was really part of the evidence of the case, that this had been a political decision to close the border, meaning to stop access to legal pathways at border crossings for everyone. So this had happened from the end of from autumn 2015. This is something that gradually happened. Only certain nationalities were allowed to cross, and from the 8th of March 2016, it was a complete stop. So this is what this case was about. But the court decided to simply ignore that fact in its application of the law, and ignored the evidence as to what the situation actually was at the border. And before I go into more detail about that, I would like to leave you with 2 of the applicants themselves and their reaction to this judgment. David, if we could have their video.
I was disappointment, even though I didn't have too much hope, but I truly hope that maybe it will be on our side for once. I mean, it will be great to have our right, you know. It is sad to see that it's that judgment. We waited 6 years and we have suffered a lot because of it. I mean, we waited months there, and now finally even though there's proof that this has happened to us, but still they ignored it.
I'm disappointed, okay, that's for sure. But I expected that. Because I always remember one Macedonian soldier once, when he walked with us to get us back to Idomeni, he told us, go back home. Europe is not your home.
I really don't get it. Truly I am. If they say it's right to do that to humans, then what's right? I really don't get it. They do send a signal, maybe for this country, it can do whatever you want with people who seek refuge, who wants to feel safe, that you can push them back, you can leave them outside in the rain, in the mud, in the cold for months.
I hope they accept us again. They will accept our rights and see us as a human. We have rights and we are not liars.
The best outcome will be that they would realize what happened to us and they will accept the facts, what they have. And I truly hope they would open their eyes and see clearly what we have been through and what I have been through with my family, what other people have been through. I truly hope that they would see what's right.
So I forgot to say, but I think it became clear to everyone who has not seen the judgment of the press release that the decision was negative and it found no violation of the prohibition of collective expulsion and no violation of the right to an effective remedy on the basis of their own culpable conduct exception defined by the Grand Chamber in NDNT versus Spain for the collective expulsion of the 8 applicants amongst 1,500 people that were collectively expelled from North Macedonia to Greece at a moment where there had been a political decision to not give them any access to any legal pathways anymore. So the legal pathways to travel or to enter North Macedonia from Greece existed until the 7th of March, and from the 8th of March they don't exist. And on the 14th of March, the applicants and others decided to walk to North Macedonia, fleeing a catastrophic situation in the informal camp of Idomeni that was hosting over 10,000 people with no state support whatsoever in a field of mud, as you heard. But the court nonetheless found that the applicants could be stripped of their rights because they had brought this situation upon themselves, and effectively punished them for what really are European policies of border migration and access to asylum. I say that because I understand how this judgment implements a certain political vision that I do not share, but that is prevalent within our politicians of how the EU wants to deal with asylum seekers at our borders, and that they should simply settle in Western Balkan countries and stop, trying to reach destinations that they may choose. And this is kind of the thinking of the court in this judgment quite clearly. It talks a lot about, a presumed sort of intention of the applicants and others, that they didn't really want to claim asylum, even though the actual intention of the applicants is never mentioned. But it's not a judgment that follows, in my view, any kind of, the court's jurisprudence or any sort of rational or legal approach, and I will explain why. This case, as I said, we filed it before the Grand Chamber decision of NDNT, but we had a chance to actually address the test laid out of own culpable conduct in NDNT quite at length. So actually, unless in NDNT, this was not possible because this exception only came at the point of judgment. So during the whole proceedings, all of these points that come in the exception in NDNT could not actually be addressed by the parties. In this case, the situation was different because the NDNT Grand Chamber judgment came about during the proceedings, and we could ask for leave, the applicants could ask for leave to actually talk about the lack of legal pathways. So this was the central pivotal point of the NDNT culpable conduct exception. And in this case, it was quite clear there had been a political decision to close those legal pathways. And on top of that, we had the applicants were able to submit not only UNHCR data saying that from the 8th of March until the 21st of September, there are 0 certificates for asylum claim registration issued by Northern Macedonia, but also press releases from the Macedonian Ministry of Interior itself confirming that fact day by day, that there are 0 certificates to claim asylum in the whole of Macedonia from the moment a decision was made to close the legal pathways on the 8th of March until months later, the 21st of September 2016. And despite that, and despite the fact that this was part of the case, but also, obviously highlighted in the submissions, the court still makes statements that it has no reason to doubt that there was not only a legal application, a legal obligation to accept asylum application, but also an actual possibility of doing so. This is paragraph 117 of the judgment, but it also says, paragraph 19, that there is nothing in the case file to indicate that it was no longer possible to claim asylum at the border crossing. And this is just not true. The whole case is about that impossibility. And so our reaction really is, what do we do with a court that simply decides to ignore the evidence? I mean, you can put all of the tests, the legal tests that you want, you can put more burden on asylum seekers at borders, and they can go through these loops and they can have evidence, and they can evidence each step of these loops with their mobile phones and try to not have them broken, and then go to the court, and the court can still in the end ignore all of that and come up yet with another version of its impossible tests. What do we do with this court that refuses to apply the convention at our borders? I don't have an answer for that question. I will just make one more point that the NDNT exception for those that, I mean, I won't go into too much detail on the legal stuff, and I'm happy to take questions about it later. But basically the NDNT exception that was carved by the Grand Chamber and sort of justified through a narrative of mass expulsions, mass attacks on the border, violent attacks on the border, has been incredibly broadened, I think, in this case, and the court says quite clearly that the use of force is no longer needed for the culpable conduct exception to apply. And it takes from Shahzad versus Hungary that even the mass aspect of the exception is no longer needed. The judgment is anonymous, yes. There was a question in the chat. Yes, absolutely anonymous. And from this judgment, all that needs to be needed is an irregular crossing. So, because even, you know, there's then the requirement of circumventing the legal procedure in place. I mean, I can explain why, but this also, in fact, doesn't apply, and the court never considers whether this applies or not. Basically, it's simply if there's an irregular crossing, the application of the court in this case is if there is an irregular crossing, there is a presumption of culpable conduct that the applicants have to absolve themselves from somehow by proving that maybe, you know, they went to the border crossing even though it was clear that it was closed, and then maybe got pushed back 22 times and then again went to the border crossing. But there, yeah. And so this hope that some people had expressed after NDNT that maybe it was a way for the court to put an obligation on legal states to actually provide for legal pathways. We can see that this is not what is happening. What is happening is we have more burden on asylum seekers at our borders, and quite frankly, requirements that are impossible to comply with and that are really far away from the situation of people at the borders. And I will stop there and maybe let, I think Zoran can speak way better than me as to what the situation at the border actually was at the time.
Thank you very much, Hannah. Thank you for an insightful interpretation of the judgment. Being a legal practitioner myself and having read the judgment, your interpretation and understanding of the impact that the judgment has is very, very useful and important. I would like to invite Zoran Dragovski to speak next. He is the head of MILA, the Macedonian Young Lawyers Association. He's also a legal practitioner and with expertise in asylum, migration, and trafficking in persons. The Macedonian Young Lawyers Association is a very important NGO that has been supporting asylum seekers and refugees in North Macedonia. And Zoran has been active there for quite some time and definitely was present in 2015 and 16. Zoran, can you go ahead and tell us more?
Thank you, Alexandra. Hi, everyone. Thank you for being here. I think that Hannah made an excellent overview of the legal challenges. I will try to give you a little bit context of what is happening here. So for the ones who are not aware, North Macedonia is not EU member state, although we are surrounded with EU member states. And in terms of asylum and migration system, I would say that there are many challenges. As in general, we have a big challenge with the rule of law in the country. So before the refugee migration situation, we have been assisting the government to build a efficient human rights-based migration and asylum system. and I must say that they were very open for cooperation, communication. UNHCR was there, but also other stakeholders. In 2015 or 16, what happened was that when the big waves of people started arriving in North Macedonia from Greece, our authorities were not aware of how to react, whether they should grant some kind of protection or they should allow the transit and so on and so forth. And we all remember certain events when some EU officials came to our officials and said, you have every right to protect your border. And they have repeatedly mentioned this even in their press statements and so on. So what our authorities did, they said, okay, we will establish this model of transit where we will allow people to transit the country as much as people are exiting the country. So for example, if today 10,000 people exit towards Serbia, we will allow new group of 10,000 people the next day. So it became like a machine, you know, every day 15, 20,000 people being issued these intentions for seeking asylum without any realistic option that these people will seek asylum in Macedonia. So they were just simply given these intentions for seeking asylum in order to make the transit legal. And we had a situation that in just several months, more than 500,000 people transited in this manner. And all of this transit, all of this certificates, as they're referred to in the judgment, they have been issued in one transit center, as it's called Vinojuk. So it's not the official border point. So it's one separate location around 2 kilometers from the official border point where these certificates have been issued. And there was a lot of political discussions, as Hannah put it. So nothing was based on the legislation. Even in November, they decided that only 3 nationalities will be allowed to transit: Syrians, Afghans, and Iraqis. So even though there is no legal basis for such a nationality profiling, those were the only nationalities who were allowed to transit. And then there was another meeting of the chiefs of the border police from North Macedonia, Serbia, Croatia, Slovenia, and Austria in February 2016. And they decided that the border will be closed. The Balkan route will be closed. So what they did is all of a sudden in 24 hours, you say no more transit. And previously had groups of 5,000, 10,000 people every day moving. And you have this situation where you have more than 10,000 people over the fence on the other side of the border, trying to enter as the ones who entered previously, and all of a sudden they're stopped. So there is no legal procedure for this stopping. It's only political decision. And it's very curious to say that when you read the judgment and you see that the court is referring that at any time these people could have applied for asylum, is very strange, because this is something that we discussed with Hannah earlier. It is impossible to cross the Greek official border point, walk for at least 1 or 2 kilometers and reach the Macedonian border point and then submit asylum claim. So it's simply impossible. You cannot just show up undocumented or without any kind of visa or some documents, and you just go to the Greek border officials and say, look, I'm going to Macedonia to seek asylum on their border point. You cannot transit, you cannot move like that. And even the geography is like that you cannot just go around the border point of the Greek authorities. So it's completely impossible. And that's why even our authorities were aware of this, even at the beginning of this refugee migration situation, that the official border point is not the place where these people will submit intentions for seeking asylum. And that's why they opened a transit center, which is just around 2 kilometers away from the official border point. And all of a sudden you read the judgment and you say, like, okay, why they didn't show up at the border point? It's because it was impossible, nothing else. So it happened what it happened in Moint that night. Me and my team, we were present there during the night. With our eyes, we saw how it looks like to have 1,000 people in a green line with the reflectors from the vehicles pointed towards them, and with army people and everyone else around them. We saw them being boarded on a trucks, army trucks, and deported at another location around 10 kilometers from the point where they entered. So you basically, you read the judgment and you see, yes, there was a collective expulsion. Yes, they did not have any legal remedy, but there was no violation. And I'm speaking from a human perspective. You know, it's even the thing that they have been returned, although you have this readmission agreement with the European Union and so on, there are legal mechanisms for such a return, even if you don't allow them to apply for asylum. You cannot just put someone in an army vehicle and just dump him over the fence and make this legal. It's impossible. Last year, 2021, we have recorded 20,000 people who have been deported to Greece. In 2020, we have recorded 40,000 people that have been deported to Greece. So since this event, until now, every year we have 20 to 40,000 people on annual basis that have been deported to Greece from North Macedonia. We have quite high number of deportations from Serbia to Macedonia. It's like a ping pong with the people, and this became so normal. It's like you catch up people and you go someplace at the border and dump them. And we were all questioning like how this judgment will affect this situation, you know, because previously, coming from a non-EU state, we were saying to our authorities, you need to reach the standards of the European Union. You need to reach the standards of the convention. You need to be in line, all your policies need to be in line with the European Convention on Human Rights. And now you have this judgment, you have their EU partners saying that, thank you, you're doing a great job by deporting everyone. And as Hannah said, you know, like what's next, you know, yeah. So this continues even today. As I said, we will be analyzing the judgment very detailed, trying not to give this powerful tool to the authorities in order to wave with it, saying that, look, we were right. So we will use all our possibilities to give some kind of interpretation and give them at least some trouble explaining that this is not approval for their actions. Thank you very much.
Thank you, Zoran, for your perspective and for the information. For the sake of clarification, I think Zoran meant to say summary expulsions or pushbacks rather than deportations, as a deportation usually is accompanied and regulated by a legislative act, and these practices that Mila has been recording, and the Border Violence Monitoring Network also has recorded quite some evidence of pushback, continuous pushbacks from North Macedonia into Greece at the same border crossing that was referenced in the judgment.
Thank you, Alexandra. You're quite right. And of course, if you ask our authorities, it's prevention from illegal entry.
Thank you for that clarification. And speaking of border crossings and borders, we have to acknowledge that each border reality is different, and that the European Court of Human Rights seems not to take this into account in its judgments. So putting new cases in, not even new cases, but cases of pushbacks or summary expulsions from different border locations to the same test as NDNT, which took place at the Spanish borders, is a reality that it's not a reality. Actually, it is not corresponding to the reality, and I look forward to hear Hannah explaining further what she means by the court ignore evidence about the realities at the border. But first, I'd like to introduce Marta Gorkniska, and apologies for not being able to properly pronounce your name. Marta, she has extensive lengthy experience in working with displaced people, including in Greece, Lesbos, where we have worked together, fortunately. She's currently a human rights lawyer working for the Helsinki Foundation for Human Rights in Poland, and she will be drawing some parallels in comparison to the cases she's been supporting at the European Court of Human Rights and her experience with the Polish-Belarusian border crossing. Marta, thank you.
Hello, everybody. Thank you for inviting me here today. Can you just confirm that you can hear me right now? Yeah, that's great.
Yes.
Okay, so yeah, as Alexandra mentioned, there are some similarities and some differences between each border in Europe, and actually Polish example can show both. As you probably know, European Court for Human Rights has already found Poland in violation of Article 4, Protocol 4, so the prohibition of collective expulsions in two cases. MK and others versus Poland, which was delivered in July 2020, and then in DA and others versus Poland in 2021. And both these cases were examined after the delivery of the NDNT judgment, where the own culpable conduct criterion was introduced. However, both of them were quite different. So both of those cases considered asylum seekers who appeared at the official border crossing, and this was the main difference here. People who appeared at these border crossings underwent the regular border control, so their presence was acknowledged by the authorities. They received the refusal of entry decision. The problem was that their asylum applications were deliberately ignored by the border guards, and this was how this pushback happened. And actually it was a wider pushback policy implemented by the Polish government already in 2015 and 2016. And it was the same for most of the people appearing at the border crossings between Poland and Belarus. So asylum applications were ignored by the authorities. And here, like I'm saying, in two cases, the violation of the prohibition of collective expulsion was found by the court. But this was very different reality from what we are witnessing right now at the Polish-Belarusian border. As you probably know, since mid-2021, there is the new border crisis between Belarus and the EU. It concerns not only Poland, also Lithuania and Latvia, but I will focus on Poland here. So we have big numbers of asylum seekers coming mainly from Syria, Afghanistan, Iraq, and Yemen, who are trying to enter Poland from Belarus outside of the official border crossings and are being routinely pushed back to Belarus. And actually, it's quite similar as in the AA case, which was mentioned before. So there are no legal proceedings. People are just simply being taken to the military tracks, and in the middle of the night, they're just being dumped somewhere in the middle of the forest and forced to cross the razor wire fence to Belarus, from where they're being, again, pushed to Poland by Belarusian authorities, which are using force, which are using tortures to push people to go again to Poland. So this is again like the human ping pong, which we know from other borders as well. Poland also passed the new legislation allowing actually for those returns, which is clearly violating the EU law and the Geneva Convention. And since October 2021, there were already almost 70 interim measures granted by the European Court based on the risk of violation of Article 2 and 3 of the Convention, in which the court obliged Polish authorities not to return people to Belarus, even though they entered in an unauthorized manner, because there is a risk that if they are pushed back to Belarus, their asylum claims will not be considered and examined. There is a risk of chain refoulement since Belarus has no, effective asylum system, and also just, simply being left somewhere in the middle of the forest in the middle of the night with the freezing temperatures is a risk for one's life and health. So this is how the situation looks like right now. Obviously, we do not have yet any judgments of the courts regarding the violation of Article 4, Protocol 4, which we are claiming in those cases. It remains to be seen, and that's why it is crucial for us to analyze the recent cases on that matter. And that's also why it was actually quite worrying for us to see today the judgment AA versus North Macedonia, since we have to, assess Polish-Belarusian border cases in the light of this judgment and also NDNT judgment. I will try to, briefly here, spot the similarities between those cases and also the differences. But what is quite worrying for me as a lawyer is what actually Hannah will explain, that there is no clear meaning right now of what actually own culpable conduct is according to the court, and we will see how it will be assessed in the Polish cases. Actually, the whole shift in the recent judgment, in the recent case law of the European Court concerning the access to the territory for the purpose of seeking asylum is quite disturbing from the human rights perspective, especially when we consider that there are limited legal pathways to the EU for people fleeing persecutions. The difference here when it comes to Poland was, at least in those cases that were already delivered, there was always a link between Article 3 and the Article 4 Protocol 4. So in those two cases that were already judged, there was also Article 3 violation found by the court, which slightly differs those cases from NDNT and NA. At least when it comes to the ruling of the court, not to the the statement of facts. In both cases, actually, the European Court already confirmed that Belarus lacks effective asylum system, which is something that here might prove that people could not use any legal pathways and official border crossings to effectively apply for asylum, but rather they used, crossing, they crossed the border outside of those official border crossings, apart from the, being forced by the Belarusian authorities. But this is also a case of many other EU neighboring countries, the lack of effective asylum system. Also, what is actually, something which is similar, that well, we know, and it was already quite well documented in several reports, including the Amnesty International report and Human Rights Watch report, that Belarusian authorities are using tortures against migrants, instrumentalizing them to exert the political pressure on the EU. So sending people forcibly to the EU, not leaving them much choice whether they want to or not allowing them to return to Belarus, but keeping, they keep them trying again and again to cross the border to Poland. But this is also not a new phenomenon, right? And we know that these practices are being increasingly used by other neighboring states, which is a result of the externalization of the migration policies, obviously. And here also, finally, what I wanted to mention is, well, we were actually discussing it with Hannah before this event. It's the problem with the criminalization of the humanitarian and legal aid, and why it is important. It is important because, well, in order to effectively run the case before the European Court, you have to, well, lawyers have to provide, full argumentation, including, the reasons why people decided to flee their countries, why they're seeking for protection, and the history of their migration route, and so on and so forth, which is actually not possible if the legal aid is criminalized, if lawyers can be press charges against because of the alleged facilitation of the illegal border crossing. We are also right now facing this problem in Poland, but obviously this is not only here. It's more and more lawyers facing this problem, and it makes it more difficult for lawyers to effectively run those cases when it comes to access to the territory, since usually you have to stay in touch with applicants both before and after they cross the border. So yeah, maybe I will end with that, and I will be happy to take your questions if there are any after this part of the meeting. Thank you.
Thank you, Marta, and thank you everyone for speaking. I'd like now to give the floor to the participants here. If you have a question, if you could raise your hand, or if you can drop in the chat that you'd like to ask a question, or also write the question in the chat. If you don't mind, I'd like to pose the first question and address it to Zoran. I would like to know, what is your assessment of the impact that the judgment will have within North Macedonia? And if there's any legal pathways left available for people on the move to access asylum in North Macedonia? And as well as if there are any internal legal remedies in the absence of a court that refuses to implement the convention.
Thank you, Alexandra. Well, first of all, I believe that they will be encouraged, because they were a little bit worried, and I must say that when the application was submitted, we had discussions with the people in the Ministry of Justice who have been working on the case, and they were super scared at that time, let's put it like this, because they consider that North Macedonia will lose this case. Because at that time there was a different reality. It was there was no NDNT, so we were, for us it was like a clear case. And now all of a sudden, a few years later, you have a completely different reality. So the problem at the moment is how to put this judgment and the whole context in line with what we consider providing protection to people in need, because it's impossible to consider that you have efficient system if you only provide protection to the ones who are, let's say, are able to come to Skopje to submit application in a police station or in the sector for asylum and have their case properly assessed. And the whole understanding of access to the procedure, I said that in the beginning, is they don't even consider, our authorities do not even consider that they are doing pushbacks. They are convinced, and they're completely repeating this to the EU officials, and everyone is okay with it, that they're doing prevention from illegal entry. Even though a person is or group of people are apprehended someplace like 50 kilometers inside the territory or any other location in the country, they're considering that they're preventing them from illegal entry. And this is the big thing now. What will happen to us? Actually, I know that it might sound strange, but we were hoping to have a Frontex operation soon, to have Frontex officials present at our borders, because at least we consider that with the Frontex mechanisms, we will have some kind of monitoring on what they are doing in a more systematic way. Because at the moment, our authorities are completely without anyone monitoring them. They can do whatever they want. They can deport people, and it's already a system. So no one is making noise because of this. Yeah. And in terms of our activities, we are still present on both borders, the border with Greece and border with Serbia. We constantly work on the two locations. We are trying to communicate as much as we can with the partner organizations, both from Serbia and from Greece, in order to litigate individual cases or cases of groups. But I must also raise this issue that at the moment, or after the closure of the Balkan route, more and more people that are arriving in our country are voluntarily want to go back to Greece. because when they go back to Greece, they reconnect with smugglers, they are able to travel again, and so on and so forth. So now we are, as lawyers, we are facing two-way problem. You know, first of all, you know that this is illegal. All these returns and the pushbacks are illegal. And on the other hand, is the will of the people, because they know that if they go back to Greece, they're able to travel again. So I'm leaving this like this because it's it's a complicated.
Thank you, Zoran, for your perspective. There have been a couple of questions in the chat. I will read them out loud. The first one is addressed to Hannah. The question is, if in the AA case, was there a complaint lodged under Article 3 as well, which is the right to the prevention of prohibition of torture, and declared inadmissible as well as in ND, or if there was no complaint made under Article 3?
Thank you for the question. There was no complaint at all made under Article 3, precisely because the case was about access to procedures. And I think I would like to make that point, that this idea, this idea that it would be a faulty thing to not have an Article 3 violation. I think it's quite interesting, actually. So we've supported another case, D versus Bulgaria, where the court made a finding on Article 3 and then said, we're not even going to consider Article 4, Protocol 4, because it's completely redundant. And this is true, because the protection afforded under Article 3 is greater. Once you've got Article 3, you don't actually need Article 4, Protocol 4. So this kind of narrative that, unless there is also an Article 3, the Article 4 Protocol 4 claim is not acceptable, is basically the court annihilating the prohibition of collective expulsions. Because once you have an Article 3 claim, the Article 4 Protocol 4 claim is completely superfluous because the protection is even less, and also because of this own culpable conduct exception. So it's quite mind-boggling to think that cases that could be successful under Article 3 would fail under Article 4, Protocol 4 on the culpable conduct point. What Marta was saying, that their current cases factually are quite similar to AA, but it's fine because they're going to be under Article 3. To think that those cases would be dismissed on own culpable conduct under Article 4, Protocol 4 is just, I don't really understand the court's reasoning there. I'm just going to take the opportunity to make 2 points, maybe. From that judgment, I think, prevention from illegal entry or from illegal border crossing is actually a vocabulary that the court now uses, and it uses it in this judgment. So it takes that rhetoric, and it's at paragraph 28, and I think that's really worrying. As a vocabulary, and I think the court's made quite clear that it doesn't care about pushbacks from inside the territory. This is not their issue. They don't care about it. They don't want to address it, and they think it's a normal way to manage borders. There was a lot of evidence submitted in the case as the systematic practice of pushbacks in North Macedonia that was completely ignored. If you search for the term pushback in the judgment, it's mentioned 4 times. Along with slight shortcomings as to the asylum, asylum procedure. The only thing that the court seems to care about is whether once the people have actually reached a border post and their presence has been acknowledged there, which is something that is very peculiar to the specific situation of borders at the Polish, Belarusian border, or the Lithuanian border, or the Hungarian border. That there, when they're registered as being at that border post, there's a denial of access to the asylum application itself. But the fact that there would be actually no access to those border posts, potentially at other borders, does not interest the court either. So in NDNT, it also made clear that if someone cannot access the Macedonian border post because the Greeks stopped them, that's not their problem. So, really the question is, what's the protection? And I think the answer must be none. The court decided to cancel the prohibition of collective expulsions. And I honestly think it's outside of its mandate. Its mandate is to apply the convention that was ratified by the states.
Hannah, I'm going to direct these 2 last questions to you as well. first. So one question reads, if you can interpret why the decision was taken unanimously against all the facts presented, and what do you think that might mean for future complaints? And what type of precedent do you think that the AA case set in terms of future cases of summary expulsions under Article 4 in the EU? And is this a politically motivated decision? And I will defer this question to the other speakers as well.
I think it absolutely is a politically motivated decision. I think the fact that it's not legally sound shows that it is a politically motivated decision, that if the law had been applied, a violation would have been found. I think that's also true in NDNT, actually. The fact that the Grand Chamber had to come up with this completely new test actually shows that there was a violation. And I think this is also what explains that it's anonymous. I think the court the judges in this judgment clearly, instead of putting themselves in the shoes of the refugees at the border and asking themselves, could they actually access border postings? Could they actually access asylum in any other way? They didn't do that. They put themselves in the shoes of EU policymakers. And those are not the shoes that the judges should put themselves into. And this whole sort of narrative of disruption, I want to say to the judges, I'm sorry, but war is disruptive. And implementing human rights, especially when states don't want to do it, is disruptive. And your role should be a disruptive role. So why aren't you disrupting EU policies? Why aren't you playing the role that you're supposed to be playing and not actually fulfilling your mandate? And I have really no answer as to why they don't do that. And I don't know who can force them to do that.
Thank you, Hannah. Those are very valid questions that I think all of us are wondering. And Marta, I would defer also to you. How do you interpret this judgment, and how do you think it will impact the current cases at the European Court of Human Rights?
Mm-hmm. Yeah, well, definitely we see in the recent years the shift in the case law of the European Court and lowering of the standards of protection of people who want to access European territory for the purpose of seeking asylum. And it's not just those cases. It's also like when you look, for example, at the case regarding, I think it was against Slovakia, when it comes to the standards of the access to interpretation, access to lawyers of people who are seeking for access to the territory. You can also see that these standards are much lower than before. So obviously it is a politically motivated decision for the court to lower those standards, and you can also see it by, analyzing the content of the judgments and how much the current migration situation is referenced to in those judgments, as it hasn't been done before. So clearly the court, sees that the migration situation is changing, that there is this, political decision to hinder access to asylum, like to the territory for the purpose of seeking asylum, and it, and it delivers judgments which are like Hannah mentioned, for EU policymakers than for the benefit of people who are seeking this kind of entry for seeking protection. So definitely I see that the standards are lowering in the dangerous ways. And yeah, we'll see the next judgments of the cases that are pending right now before the court. There are actually a lot of them concerning Article 4, Protocol 4, including those many cases against Poland. Would you like me, to answer also this question regarding the criminalization of the legal aid, because this was something that I was mentioning. So maybe just shortly, I will just say how it looks like in Poland right now. So as you know, maybe that once the crisis started, the state of emergency was introduced along the borderline with Belarus, which means that no lawyers have access to this area. So lawyers cannot access people who are already on the Polish territory seeking for access to asylum proceedings. And if you do access this, state of emergency zone, you can be fined, or the criminal charges can be brought against you, which makes it very difficult for us to collect the facts to submit the complaints to the European Court. Also, there are these threats of, and like when you get in contact with border guards at the border, you're very often being threatened by the officers that what you're doing here is illegal, because it's actually facilitating the illegal border crossing. So for people delivering humanitarian aid in very difficult condition in the forest, or for people delivering illegal aid, it's always a risk that you might be, that there might be criminal charges brought against you. And actually, in the last week or 2 weeks, we had 5 activists already arrested, and the prosecution demanded the pre-trial detention for 3 months for all of them. So we see that this atmosphere around it's getting only worse in Poland right now. Actually, today there was this Twitter of the border guards accusing activists to take power of attorneys from people before they reveal themselves to the authorities. But any other way, it's not possible to lodge a complaint if you do not have the power of attorney, the story of a person, and their the reasons why they're seeking protection. So this is what we have to do before they actually approach or they meet authorities, because once they do, they can be very quickly pushed back to Belarus. So this is why it's right now very difficult for us to work under these conditions. And like I'm saying, more and more people face criminal charges for providing this kind of assistance. Thank you.
Thank you, Marta. And also, I think it's worth mentioning how the lowering of standards for people on the move to access protection mechanisms and permitting and ignoring that states are no longer granting and ensuring that they do have access to those protection mechanisms will have a very direct impact on activists, on legal practitioners who are trying to support people on the move, to ensure and exercise their rights, as well as to have access to these protection mechanisms. Hannah, you have another question with regards to the judgment. What are the next steps for the applicants and for the ECCHR? Will there be an appeal? Will there be another type of legal action with regards to this case?
Yeah, I mean, I don't know if I said this at the beginning, but all of the applicants have reached a place of safety, and thankfully they didn't wait for the Strasbourg court to save them. They would have been disappointed. So, they are safe and they are fine for years now. As to the case itself, I think the applicants and their lawyer need to consider whether they want to do a referral to the Grand Chamber, whether it's worth it, the effort that this takes when we know the Grand Chamber's positions. And this hasn't been decided yet, but it's definitely a possibility. However, even if you ask for a referral to the Grand Chamber, it needs to be permitted by the court itself. And it's quite unclear whether the court would actually allow that.
Thank you very much. I would like to address one last question to all the speakers here today, and that is, what do we do as legal practitioners in a time where the European Convention of Human Rights is no longer an ally? And as Hannah has said, and the others have exemplified through their experiences, that does no longer apply the convention in a matter to protect the rights of those vulnerable, but putting itself in the shoes of European policymakers. Would you like Zoran to answer first, maybe?
Thank you, Alexandra. I go a little bit back and I can come back to your question on the what does the case set in terms of future cases. So I think Hannah mentioned at the beginning that compared to NDNT, this use of force in order to enter the country, all these things are not valid anymore. So you just, as the court says, the applicants place themselves in jeopardy. So if you put yourself in jeopardy by entering illegally, you're not entitled to any kind of protection in terms of the convention rights. So this is very dangerous, according to me. It's very, very dangerous statement. And we will see how this will reflect on other cases, probably, maybe in future. And your question was regarding what is the motivation, or actually what are the other legal challenges. I would say in our context, I'm not so sure about the other locations, but in our context, we need more media coverage. We need more presentation of what is the real situation, trying to, as much as we can, to avoid this fake news and all this panic around the migration. We need this pressure from the people, as utopistic as it sounds, because I think that the decision makers are following the voices of the people, of the general population. So if we manage to reach them, then and presenting these issues, you know, for us it's no longer migration or asylum. For us, it's a rule of law. We either have rule of law in the countries or not. Thank you.
Thank you, Zoran. Marta, Hannah, would you like to take a swing at this? And of course, I don't want to forget people on the move themselves who try to access remedies for the violations that they have suffered. So what's left for them as well when the court is no longer applying the convention in the way it's meant to be?
I know, yeah. Should I start? Yeah. Well, actually, maybe my last comment here, and actually partly, you know, answers your question and partly answers the question that was here put on the chat regarding Ukrainian border. Maybe I'd like us to remember that and, you know, see that, you know, Poland managed right now to receive more than, I think, 2 million people already from Ukraine in the first 3 or 4 weeks of the crisis there, of the Russian invasion. And it just proves that it can be, you know, it can be done in a safe way. It doesn't pose a threat. People don't have to die at the borders, you know, in order to you know, to find a safe place to stay. So for me, it's a proof that, you know, with the political will, it can be done, and it could have been done on so many other, you know, European borders, especially when you compare the Belarusian and the Ukrainian border with, like I'm saying, over 2 million people coming from Ukraine in the first few weeks, and, you know, only, you know, like maybe 15 or 20,000 of people coming through the Belarusian border to Poland, which is, you know, nothing compared to over 2 million. And still we had, you know, so many people who died in this forest, so many people who died because of this border and the border policy, which shows that, you know, different policy is possible. And maybe this is something, you know, to remember. Thanks.
I think from ECCHR's point of view, we will not stop putting the reality of the border in front of Strasbourg whenever we can. And I say we can because the changes of the rule, the changes of the court's rules, only giving 4 months to file, don't make it easier in pushback cases. This means you have 4 months from the time of the pushback to the time you file, which is humanly very difficult. And I think it's essential until it gets it right. And I hope that academia takes it over with its careful analysis of what the court is doing. And because I think only academia can, in a way, hold the court accountable to say what you're doing doesn't make sense. And it needs to start making sense if you still want us to take you seriously as a court of human rights, the highest human rights court in the Council of Europe. I mean, this is not a small mandate. And what we see now is simply unacceptable, and we won't stop until it is an acceptable, you know, case law. because, you know, the court would like nothing else than we stopping to put these cases in front of it. It would be so easy.
Thank you, Hannah. Thank you, Magda and Zoran as well. Thank you. Indeed, let's not make them feel, let them not be comfortable in their high chairs. Thank you for speaking today and for introducing us to the case and to the repercussions and the impact of this case. Thank you for all the participants and for your questions. I think we can wrap up the panel discussion here now, if that's okay with everyone. It's been lovely to be part of this conversation and to moderate it to the best of my ability. I have received very insightful comments and opinions on the matter, and yes, thank you everyone for today.
Thank you.
Thank you very much, everybody.
Bye.
Bye-bye.